What's up, everybody? Sydney here. I'm going to explain to you exactly what's going on. I know that a lot of you have been following me for a while, especially under the trust and estate administration sides of the world, especially if you're in Canada and the United States, and why I've been moving everybody into a common law organizational trust and trying to protect you and shelter you from the situation that is actually playing out in the general public as we speak. And it's because there's a really big secret that the Canadian citizens, as well as the Americans, are not actually being exposed to or being told. And I'm going to expose to you right now why Mark Carney is actually in Canada. So it actually has to do with Canada being liquidated. Canada is in probate at the moment, which means that the Trust and Estate Administration, he's been appointed as executor on behalf of the Crown to basically liquidate and probate the estate so that Canada can go into the United States of America legally and lawfully. That's actually the right answer. And I know a lot of Canadians in here, especially First Nations and all you guys, are not going to agree with me, but it is what's being done as we speak. And there is a 90-day system going on right now, which is January, February, and March. And that's why the big actions are actually going to take place in March. There's a reason why this is happening, and I know that people don't really know anything about asset-backed securities. That's why Mark Carney is actually here. It's because he was the Governor General of the Bank of Canada, the Governor General of the Bank of England, tied directly to the Crown, which is all of the allodial titles in the asset-backed securities. That's why Justin Trudeau had to step down, and that's why he has to step in to the position of an unelected PM in order to be able to get what's called an administration bond in order to liquidate the affairs, because he is one of the most foremost authorities on asset-backed securities in Canada and the United States. And again, here are some of the examples why probate will be necessary. Financial institutions. In order to release funds from the deceased accounts, a financial institution or a broker, according to internal policy, will require the will to probate unless the value of the accounts is below the threshold. Title of assets. When transferring assets, the ownership of which is recorded in registers, the record-keeping authority must be satisfied that the executor has the power to deal with such assets, meaning they got to be competent. Examples of this class of property are land, bonds, public corporate shares, and valuable art, which can be donated to charity. Property outside the jurisdiction. If some of the estate assets are situated outside the province, it is necessary that an application be made to the court in that jurisdiction that the property be dealt with. Probate will have to be issued in the province where the assets are situated, so that the application of resealing or ancillary grant can be made. Involved in litigation. If the estate is involved in litigation, obtaining probate will be necessary. Litigation is actually quite common with the Crown, especially when dealing with First Nations. Now you know why they're doing what they do. Will provided. So let's just move on. I'm going to bring you to the important part. It's the testator's nominated executor. So this has to do with what Queen Elizabeth's orders that just came out and got released, and why you now know why Carney is here. To illustrate the court's reluctance to set aside the testator's nominated executor, even a person in prison or a non-resident individual may be appointed. This direction is allowed if the will does not state who the executor is to be, but delegates the right to another person or a group of persons to name the executor, such as the following. By permitting the testator to allow the person to nominate the executor, the court is recognizing the testator's right to choose whomever he or she wishes to administer the estate. It is felt that the testator's choice will be one better than that would result from the following arbitrary rules made for that purpose. They don't want this going to court. They just want it dealt and done and over with. It was part of an agreement that was done to liquidate the estate of Canada so that it can be entered into the United States under a backdoor contract, because they want all of North America united under one system. This is a true story. This is happening right now as we speak. Non-resident executor. So for those of you that are Canadians in here and you're lawyers and attorneys or any of the citizens that think that you understand that because, oh, they're not citizens, they hold citizenship in other residencies, they have other things going on. Mark Carney is not Canadian. He's English. He's this, he's that, he's our... You don't know the law. You don't know trust and estate administration. So listen to what they say about non-resident executors. A person need not be a resident in the province or in Canada to be an executor. However, if the person resides in a jurisdiction other than another province of Canada or the British Commonwealth countries, it is necessary for the non-resident to post an administration bond unless the will specifically waives the bond, or 2, the beneficiaries consent to a waiver of the bond, or 3, a judge agrees to make an order allowing the bond to be waived. So even the first one in there, the executor has to post an administrative bond. That's why Mark Carney is in Canada as an unelected going into the PM position, because he will be granted an administration bond in order to act as the executor to liquidate the affairs of Canada over to the United States. For those of you that think for some weird reason that this is not happening, that Canada isn't part of the United States, they are actually accumulating all of the assets right now. They're getting all the records in place. They're getting everything constructed. That's why Parliament is prorated. You can't pass laws when you're under probate. Nothing can move under probate. Everything must be settled out. All transactions have to be settled. That's why nothing is moving. That's why Mark Carney is here. That's why you're seeing all of these things play out. It's all part of the script. That's what's going on in the world. So anyway, welcome to the wonderful world of trust and estate administration, and welcome to the backdoor deals that happen around the world that you probably don't know shit about. And just to take it one step further, I'm going to give you the smoking gun. International wills, not applicable in Northwest Territories, Nunavut, Quebec, and Yukon, conveniently territories and a civil jurisdiction. On October 26, 1973, in Washington, D.C., various jurisdictions signed a convention providing a uniform law of form of international will. The intent was to assist testators with assets in multiple jurisdictions. A jurisdiction may be an entire country, or in countries such as Canada, each province is a jurisdiction. The countries and the states that signed the convention recognize that the will made in compliance with the annex to the convention. In other words, if a person domiciled in Belgium, a signatory jurisdiction, signs a will in Belgium according to the prescribed international form, then all other jurisdictions who are party to the convention will recognize that the will as validly made within their jurisdiction. An international will is one signed in according to the requirements listed in the convention. One requirement is that the will be signed before 2 witnesses and an authorized person. Sound familiar? Authorized person? In Canada, an authorized person is a lawyer. Another requirement is that after the will has been executed, the authorized person must complete a certification form. Isn't that interesting? These wills are very rarely used since the person usually makes the will when they are at home, but those wills are validly made in accordance with provincial and state requirements. So Canada was a signatory on the International Wills Convention on October 26, 1973 in Washington, D.C., which means, yes, the full jurisdiction is there to liquidate the assets, and to the First Nations community, your treaty and agreements were with the Crown, which was a subsidiary, which means that the jurisdiction, your fight, isn't actually with the Crown. It's with the United States of America, because that deal has already been done and it's in probate right now to liquidate all of the estates and all of the assets. Now you know why I moved everybody into a common law organizational trust registered with the Secretary of State in the United States, so that you guys were protected during this transfer stage. You're welcome.